I just wanted to give another, well, better wait. Hello, everyone. This is Matt Thompson, and I just wanted to give another Jeff Weinhaus update. And I think at long last, we're finally getting closer to a decision in this case. As I've said many times before, I think the Jeff Weinhaus case is very, very important case because Jeff was merely criticizing the government, and we have to have a right to criticize the government without getting shut down, without getting assaulted. And Jeff, as a result of his publications, was raided by police. He was subsequently invited into an ambush and where he was shot twice in the head and twice in the chest. And then he was incarcerated, convicted, and incarcerated, and is serving a 30-year sentence for assaulting the officer that assaulted him, even though this officer was never assaulted in any way. And so he's been through lots of dramas, appeals, and habeas cases. And just this last year, new information was revealed in the case, which really just blows the whole government's case against Jeff out of the water. And thankfully, the Missouri State Public Defender's Office was able to take the case back up, and they filed a habeas case on behalf of Jeff Weinhaus in April of this year. The court set it aside until May and then gave the state until June 22nd, I think it was, to respond. The state has responded, and Friday was the last day, or no, excuse me, yesterday was the last day for Jeff to reply to the state response. And that reply was filed by Amy Bartholow of the Missouri State Public Defender's Office. So now it's in the hands of the judge. And I would just like to really thank the Missouri State Public Defender's Office, everyone who's worked to help Jeff with this case in that office, and especially Amy Bartholow, who I think has done just an outstanding job. And she's presented an absolutely compelling case for Jeff to be released. And so now it's up to the judge to see what happens. I'll read maybe a few details from the filing that was filed in reply to the state response yesterday. And it says respondent. So in this filing, when she's talking about the respondent, she's talking about the state. The state of Missouri is the respondent in this case. Respondent concedes that the state failed to disclose evidence that its key witness, Sergeant Folsom, suffered from post-traumatic stress syndrome and was under the influence of psychiatric medication at the time he was shot. At the time, Mr. Weinhaus was shot 4 times. Respondent's pleading does not deny or dispute Fact 1, that the Missouri State Highway Patrol learned of Sergeant Folsom's condition following a mandatory drug testing immediately after this officer-involved shooting. 2, that defense counsel timely requested disclosure of impeachment evidence about the state's witness. And 3, that the state did not disclose this information despite its duty to do so. Instead, respondent's sole argument on the actual merits of Mr. Weinhaus' petition is that the state's failure to disclose Folsom's medicated psychiatric condition was not material and thus not sufficiently prejudicial to require redress by this court. Fortunately, despite respondents' invalid procedural objections discussed below, Missouri's Rule 91 jurisprudence empowers this court to correct the fundamental miscarriages of justice, such as the one that has been suffered by Mr. Weinhaus. Indeed, habeas review is driven by the imperative of correcting a fundamental unjust incarceration. And then it cites the case Clay versus Dormier in 1985. Respondent's scant recitation of the facts in the final 3 paragraphs of its response is both incomplete and inaccurate. This court should not accept respondent's attempted diminution of the importance of Folsom's perception of events upon the jury's verdict. or the significance of not being able to impeach those perceptions with the fact that he had experienced them through the lens of PTSD. A review of the state's evidence clearly shows that Mr. Weinhaus' conviction hinged upon Folsom's perception of Mr. Weinhaus's illegal actions. First, respondent fails to mention that the jury found Mr. Weinhaus not guilty of identical charges involving Corporal Mertens. To assert that Mertens' testimony merely mimicked Sergeant Folsom's is simply incorrect. It is more reasonable to assume that the jury disbelieved a significant portion of Mertens' testimony because it convicted only the counts where Folsom was alleged as the victim. Mertens, in fact, testified that he never saw Mr. Weinhaus' weapon come out of the holster, and he did not see the butt, handle, or grip of Mr. Weinhaus's gun. He only saw him reach underneath the holster, according to Mertens. Mertens also testified that when Mr. Weinhaus fell to the ground after being shot in the head and chest, the weapon was still in the holster. He never saw the weapon out of Mr. Weinhaus's holster. Second, respondent attempts to paint a nefarious gloss on the fact that there were 3 loaded weapons in Mr. Weinhaus's car, yet the state has never once asserted that Mr. Weinhaus did not have every legal right to own and possess those weapons. Indeed, Mr. Weinhaus was never charged with possessing an unlawful weapon of any sort. Further, the record shows that when Mr. Weinhaus met up with the officers under the ruse concocted by them to return his computers, he did not exit his vehicle with anything but a lawfully holstered weapon on his hip, which he is entitled to openly carry under Missouri law. There is absolutely no evidence that in the mere seconds between Mr. Weinhaus exiting his car to when he was gunned down by Folsom that he ever tried to access any weapon. Indeed, the one and only issue for the jury's resolve was whether Mr. Weinhaus was attempting to draw his weapon at the time Sergeant Folsom shot him. This is precisely why the existence of Sergeant Folsom's pre-existing PTSD diagnosis and his medicated condition were so critically important for the jury to hear. Had the jury been privy to the lens through which Sergeant Folsom was experiencing and describing this encounter with Mr. Weinhaus, it would have made a material difference to the verdict. For example, with expert testimony, defense counsel could have educated the jury about the dangerous misperceptions caused by the hyperarousal of Folsom's PTSD. Indeed, following the shooting, the respondent, Folsom's own doctors, determined that Sergeant Folsom's PTSD gives him false signals of being under threat and that he is fearful of pulling a gun and shooting someone when they are merely reaching into their back pocket for a wallet. After Mr. Weinhaus' trial, respondent litigated at length against Sergeant Folsom in a sealed civil wrongful termination case to establish just how serious Folsom's PTSD condition was and is, and how it prevented him from holding a job in law enforcement. Yet now, respondent claims that such evidence, undisclosed in Mr. Weinhaus's criminal case, is simply not material. Such assertion is not only inconsistent, it is decidedly disingenuous. If this admittedly undisclosed condition was material enough to end Sergeant Folsom's career in law enforcement, it was certainly material for the jury's consideration before taking away Mr. Weinhaus's freedom. So that just gives you this goes on, and I'm going to give you the full document in the comments. But there is a very, very strong case. Obviously, what happened was Sergeant Folsom, after he shot Jeff, was relieved of his duty on the day. He was kept on the payroll for 2 years. And after Jeff was convicted and his appeals were exhausted, then Folsom was dismissed. And in the last couple of years, Folsom sued the state for his dismissal. And that's where all this information about him being on medication for post-traumatic stress syndrome came out, that he had a psychological condition which would cause him to feel threat when there wasn't. And this was in Folsom's case against the Missouri State Highway Patrol, but yet, it was never revealed to Jeff's defense in the trial. Jeff had his gun in the holster. FBI agents testified that he never reached for the gun. Both his hands were in front of him. and he never assaulted or intended to assault the officer in any way. And now this case is going to the judge in St. Francis Circuit Court. We've never been overly optimistic about our chances in this court, but hopeful that under appeal that we might win. But the case is now so strong that we feel that the judge should be able to rule in Jeff's favor in this case. So now the next step is for the judge to take it into consideration. At the close of Amy's response, let me just find it here. She's asked that the judge either A, grant the writ of habeas corpus immediately, and in such case, Jeff Weinhaus, the warden at the prison where Jeff Weinhaus is, would be ordered to release Jeff into our custody of friends and family, and B, or conduct an evidentiary hearing, or C, grant such further relief as the court deems consistent with the ends of justice. So we don't know whether the judge will just rule or whether the judge will call a further evidentiary hearing. But again, I think Jeff's legal team has made an extremely strong case. I'm very proud of them for having the courage to take this case up and to realize its importance, and for the work that Amy Bartholow did on it. And we're just hoping and praying that the judge might see past any pro-law enforcement bias that he might have and look at the actual facts of this case and decide in favor of justice. So again, I'll put this document in the comments, and I'll update you as soon as we hear anything from the judge in this case, or if we get anything further. But again, we've made a very strong case for habeas release. The state has responded to that case in which they haven't denied any of the basic facts of the case. And then Jeff's lawyers have made a reply to their response, which was very compelling and really makes the entire case for Jeff to be released. And I hope that the judge will do it, and that he will do it very, very soon. And thank you all for all your concern for Jeff, for praying for him. He's praying for all of you every day. I know I talk to him, and he's always praying for everyone else. And he's a good man, and I'm hopeful the judge is going to do the right thing. Thank you all very much. Bye.